Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today I've got a very important update in a very important case called Mock v. Garland, which is a case that was filed in the state of Texas by the FPC, and it's a case that's challenging the ATF's new brace rule. The FPC asked the courts for a preliminary injunction, or they asked the court to at least extend out the start date. So we got an answer. The court filed its answer today, so let's talk about it. This channel is proud to be sponsored by the USCCA, absolutely one of the best memberships you could ever have in your wallet. As a member, you get that self-defense liability insurance, which is priceless. And don't forget, in March, if you sign up for all tier levels, any tier level, you get the range bag and you get the cleaning kit. Now, if you want to step it up and go to the platinum or elite levels, you're also going to get that Pelican Vault case, which is really nice case. So definitely check out the link below and sign up today. So the FPC filed this lawsuit in Texas challenging the ATF's new brace rule, saying that it violates the APA, the Administrative Procedures Act, and that it also violates the First Amendment, the Second Amendment, and the Fifth Amendment, and they have a very strong case. Remember that this is all happening post-Bruin, where the courts are supposed to look at text, history, and tradition, not public interest or government interest, things like that. They're supposed to base it off of those criteria. Well, this is what the requirements the court says that they have in order to determine whether or not the injunction should go through or whether or not the start date should be postponed. So I'm going to put this up on the screen here so I can read it for you guys real quick. Now, all this information can be found on the district court's order. I'll put a link down below if you guys want to check it out. It's a pretty long order, actually, but I'll put it there if you guys are interested. So it says here, the legal standard to obtain a preliminary injunction, the movement must demonstrate, 1, a substantial likelihood of success on the merits, 2, a substantial threat of irreparable harm, 3, that the balance of hardship weighs in the movement's favor, and 4, the issuance of the preliminary injunction will not disserve the public interest. Again, with that whole public interest thing. Now, in my opinion, I think that the FPC and their arguments have proven all of those 4 factors. Now, it says here the last 2 merge when the government is the opposing party. As movement, the party seeking relief bears the burden of proving all 4 elements of the preliminary injunction. And while the decision to grant or deny injunctive relief is committed to the district court's discretion, such relief is considered an extraordinary remedy, never awarded as of right. Okay, so those are the terms of a preliminary injunction. If you're asking for a preliminary injunction, the court is saying that your burden is to meet those 4 criteria. So that's what the FPC was challenged to do. Now let's go ahead and read what the court decided to do in this case. Did they grant the preliminary injunction, or did they just simply blow it off and side with the ATF? So it says here, United States District Court, Northern District of Texas, Fort Worth Division, opinion and order on plaintiff's motion for preliminary injunction or, in the alternative, for postponement of the effective date of the final rule. Before the court are plaintiff's motion for preliminary injunction or, in the alternative, for postponement of the effective date of the final rule, and briefing in support, filed February 21st, 2023, defendant's opposition, filed March 10th, 2023, and plaintiff's reply, filed March 17th, 2023. Having considered the parties' briefing and applicable law, the court holds the plaintiffs have not carried their burden to demonstrate their substantial likelihood of success on the merits of any of their claims, and therefore denies plaintiffs' motion for preliminary injunctive relief or, in the alternative, for postponement of the final rule's effective date. So the District Court of Texas has sided with the ATF and the ATF's ability to do what they did, and the court has denied both the injunction and the postponement of the effective date. So why did the court deny this injunction? Well, I read the 16-page opinion that went with the order, and the court basically sided with the ATF, saying that the ATF was created by Congress to regulate and enforce the NFA and the GCA, and that this falls within the purview of the NFA and GCA, this particular regulation and rule, and so the ATF is well within its scope. And to put it into a nutshell, that's kind of what this opinion says. And so they sided with the ATF and Garland over the FPC and other plaintiffs. So, I mean, in my opinion, this is completely backwards, right? It's completely backwards. It's clearly a violation of the ATF scope. It's a violation of the First Amendment, the Second Amendment, the Fifth Amendment, and so forth. And all of the FPC's arguments are 100% valid, but they interpreted things wrong, again, using different interest balancing approaches. Again, that's not what the court is supposed to do here. And they're saying that it's an extreme measure to grant an injunction like this, when in reality, it's not an extreme measure. The courts are there to protect our fundamental rights and not to side with the government. It's to look at things through a constitutional lens only. So what does this mean? Well, it means that we were let down by the lower courts once again. That seems to be a recurring theme. The lower courts tend to let us down a lot. This also means that we're going to have to appeal. I believe that the FPC and MOC will appeal this, and it will go up to a higher court. So we'll have to see what the higher court has to say about this. Again, there'll probably be a little bit more discovery, a little bit more information. There's going to have to be more briefs that are filed. This is going to take a long time. The court system moves very slow. These things all move very slow. But still, with this appeal going up to a higher court, maybe we'll get a different answer. But again, Garland could always appeal that decision. So the likelihood of something like this ending up at the Supreme Court is pretty high at this point. There are multiple lawsuits that are challenging the final brace rule, and I think that at least, at minimum, one of those will end up at the Supreme Court, and the Supreme Court's going to have to decide this one. So I just wanted to let you guys know about that. Injunction denied by this district court in Texas. It's you know, it's disgusting, really, in my opinion. It's disgusting that they would side over a government agency over the people, but that's what they did. So I want to let you guys know about that. Thank you all very much for watching. I do appreciate it. Please like, subscribe. Have a great day.